Hello, doctors. I'm Dr. Chris Rapoff of D.C.QME Continuing Education, and welcome to this week's presentation. Today, I'd like to discuss a topic that can be somewhat confusing to those of us working in the realm of workers' compensation in the state of California, and it has to deal with the Subsequent Injury Benefit Trust Fund. And it's under Labor Code Section 4751. Exactly what is this fund, and how is it practically applied? Well, let's take a look. These are the sources that I referenced when producing this presentation. Feel free to copy and paste these links into your browser if you'd like to read more about the Subsequent Injury Benefit Trust Fund. Over the past several years, there's been quite an increase in the number of workers' compensation cases dealing with the Subsequent Injury Fund under this Labor Code 4751. So what is it exactly? Well, this fund is a source of additional compensation to injured workers who already had a disability or an impairment at the time of a subsequent injury. So for benefits to be paid from this fund, the combined effect of the injury and a previous disability or impairment must result in a permanent disability of at least 70%. Kind of confusing, I know. The fund allows employers to hire disabled workers without the fear of being held liable for the effects of a previous disability or an impairment. This fund also benefit checks are issued by the claims units after the benefits are awarded by the Workers' Compensation Appeals Board. Now, what is the cause of the confusion surrounding this Labor Code Section 4751? Well, the primary issue is whether or not an injured worker qualifies for additional compensation under this fund. There are many other issues and strategies that one needs to become familiar with as they attempt to understand this code section more fully. So to enlighten us a bit, we'll explain that the legislative intent behind this Labor Code Section 4751 was explained by a workers' compensation judge in the Contraction versus this fund in 2011. The judge stated that this fund was to allow people with pre-existing disabilities to have an opportunity to obtain gainful employment without the employer worrying about being economically responsible for a pre-existing condition should that worker incur a work-related injury that causes the pre-existing disability to get worse. Yet, there must be some form of mechanism in place to assist the employee should his or her disability actually increase. So the statute itself is complex and rather difficult to understand, as you'll see here in a minute. This creates confusion for those of us trying to understand this potential benefit to the injured workers. And understanding this fund is probably best illustrated by taking a look at the code and then providing some examples of its use. First, what is Labor Code 4751? You'll be surprised. Well, there you have it. Here is the contents of Labor Code Section 4751. For those of you who choose not to read this, I'll read it for you aloud so you can hear it. If an employee who is permanently partially disabled receives a subsequent compensable injury resulting in additional permanent partial disability, so that the degree of the disability caused by the combination of both disabilities is greater than what would have resulted from the subsequent injury alone, and the combined effect of the last injury and the previous disability or an impairment is a permanent disability equal to 70% or more of the total, he should be paid in addition to the compensation due under this code for the permanent partial disability caused by the last injury compensation for that remainder of the combined permanent disability existing after the last injury as provided in this article as I'm reading to you. They say either a previous disability or an impairment affected a hand, an arm, a foot, a leg, or an eye, and the permanent disability resulting from this subsequent injury affects the opposite and corresponding member, and such a later permanent disability, when considered alone and without regard to or adjustment for the occupation or age of the employee, is equal to 5% or more of the total. Or B, a permanent disability resulting from the subsequent injury, when considered alone and without regard to an adjustment for the occupation or the age of the employee, is equal to 30% or more of the total. There you go. So, as I said, a little confusing, huh? Well, you did read that correctly and you did hear me correctly. That is the legislative statute or the actual section of 4751 Labor Code. Now, the state legislature, in their infinite wisdom, strung together, if you count them, 217 words in one long run-on sentence, hoping the reader might take some sense out of it. Nice try. But let's see if we can make some sense out of the 217-word run-on sentence. Now, first, number one, the employee must have a pre-existing permanent partial disability, which may be industrial or non-industrial in origin. Number two, this employee must have a subsequent industrial injury, so a prior non-industrial or industrial injury, and then a subsequent industrial injury. Now, number three, two disabilities, what I just mentioned to you, number one and two above, combined must be greater than what the employee's disability would have been if the employee suffered only the subsequent and not the pre-existing disability. Now, finally, these two disabilities combined must be equal to 70% permanent disability or more, a great high threshold there. And when the pre-existing disability is combined with the subsequent disability, the resultant permanent disability must equal to 70% or more. So not only is this a high threshold to qualify for or to meet, there are some other important considerations. One of the following must be met as well. The pre-existing disability must have affected a hand, an arm, a foot, a leg, or an eye, and the subsequent injury must affect an opposite and corresponding member, and the disability from the subsequent injury must be equal to 5% or more of the total without an adjustment for age, occupation, or apportionment. And the other criteria could be met is the permanent disability resulting from the subsequent industrial injury, when considered just alone and without regard to or adjustment for the employee's age, occupation, or apportionment, must be equal to 35% or more of the total. Again, very large. Now, there's no statutory time either for them to file an application against this fund. But an application must be filed with a reasonable time after an applicant learns from the board's findings on a permanent disability that this fund may have liability. Now, practically speaking, let's set the stage and see if you can understand this a little more fully. Considering the following set of facts, Ms. Eidman, she's working as a grocery clerk and she sustained an injury to her back in 1991 and again in 1993. Now, Dr. QME evaluates Ms. Eidman and determined that she was precluded from very heavy work, equivalent to 15% permanent disability per the 1997 Permanent Disability Rating Schedule. As a result of her industrial back injuries of 1991 and 93. Now, he also declared to be a qualified injured worker. These cases were settled by compromise and release in the past. Ms. Eidman changed occupations, and now she's become a paralegal. And on November 20th of 2002, she suffers an industrial injury to her spine and her psyche, and is now considered 100% permanently disabled. So what is the result here? Well, a panel decision actually was made of the Eidman versus the law offices of Thomas Plum, and the Workers' Compensation Appeal Board affirmed a workers' compensation judge award of the benefits for Ms. Eidman for the following reasons. Ms. Eidman established that she had a pre-existing permanent back disability and was determined by the evaluating physician to be a qualified injured worker. Now, this precluded her from very heavy work, which was a 15% standard. Now, Miss Eidman had a subsequent disability to her spine and her sight. These two disabilities combined were greater than what Miss Eidman's disability would have been if she had suffered only the subsequent injury and not considered the prior injury. Now, finally, these two disabilities combined resulted in Miss Eidman now being considered 100% permanently disabled, which is equal to the 70% permanent disability or more threshold that she had to meet for this fund to come effect for her. Now, they also bring up a case that this regarding pre-existing disability. And in addition to just having pre-existing disability, the case law has actually established that this pre-existing disability must be labor disabling. And this was as a result of a court case in 1958, believe it or not, Ferguson versus IAC. And they summarized by saying that they held that to qualify for this subsequent injury fund, an employee must show that prior to the occurrence of the subsequent industrial injury, he or she had attained a factual status of the permanent partial disability, and that such previously incepted disability, the prior one, was labor disabling. But that the previous knowledge, therefore, that the employee is not inherently, as a matter of law, required as a condition to be an award of the employee of payments from the subsequent injury fund. A little confusing, but they're just trying to get us to understand that this prior disability had to be a labor disabling disability. Okay, so for example, consider this set of facts regarding that mandate of a pre-existing disability to be labor disabling. Right? In this case, we have Mr. Becerra, who had a pre-existing injury in the form of a partially amputated index finger. Now, Mr. Becerra had a subsequent industrial disability to his back, working as a truck driver, which was equivalent to 97% permanent disability. So he had a pre-existing disability of a partially amputated finger and then a subsequent disability of 97% from his back. Now, Mr. Becerra argued that the two disabilities combined was greater than if he had only suffered the subsequent back injury of 97%. And so both the back and the pre-existing finger amputation were part of his claim. Now, the fund used vocational rehabilitation expert, and the evidence that they established was that Mr. Becerra was 100% permanently disabled from his back and not involving the finger. So that pre-existing injury did not contribute to his 100%. So that's what the question was here. Now, what did they say? Well, in this case, Becerra versus the Workers' Compensation Appeals Board in 2011 pretty much denied this case. The court held that there was substantial medical and vocational rehabilitation expert evidence that established that an industrial injury alone exceeded the 100% permanent disability, and that Mr. Becerra's work was not hampered at all by his pre-existing injury to his finger as a truck driver. So therefore, he did not meet the threshold standard that was required for a distribution of those benefits through the fund. All right, let's take another example here. In recent years, judges really have struggled with the correct interpretation of this Labor Code Section 4751, and specifically how they would calculate the percentage of an applicant's subsequent whole person impairment for the purpose of meeting this threshold. So here's another example, some facts. Officer Galetko was a CHP officer for 30 years, and then he retired. Officer Galetko had a pre-existing non-industrial injury equivalent to 60% permanent disability. So after his retirement, Officer Galetko was awarded 66% permanent disability for a cumulative trauma ending with his heart, digestive system, excretory system, his head, and his back. Everything was involved here. So Galetko's industrial injury was comprised of the following: 8% lumbar spine, 8% thoracic, 3% for lumbar pain, 7% for cardiovascular, 5% for upper gastric, and 5% for tension headaches, which 50% was considered non-industrial. So the workers' compensation judge looked at this and multiplied the above whole person percentage by 1.4, which is part of the disability rating, and then they added them together. He added them together for a total of 47% permanent disability instead of using the combined values chart to determine whether or not Officer Galetko met the threshold for the benefits. Let's take a look at what they determined. Okay, so what are your thoughts on this? Did the workers' compensation judge calculate the 47% permanent disability correctly? Okay, did he qualify for benefits? Well, there was a panel decision of the Galetko versus CHP in 2016, and the Workers' Compensation Appeal Board held that the workers' compensation judge correctly calculated the 47% permanent disability by adding the impairments together rather than using the combined values chart. Also, the two disabilities combined was greater than what Officer Galetko's disability would have been if he had suffered only a subsequent industrial injury, not the pre-existing non-industrial disability. So in addition, the two disabilities combined would be 107%, which is equal to 70% permanent disability or more threshold. So therefore, Officer Galetko clearly qualified for those benefits. So there you have Labor Code Section 4751 as it describes the process for meeting the threshold for obtaining the subsequent injury fund benefits. Now, although at first it appears to be a kind of a long, incomprehensible, daunting sentence of 217 words, the principles, once they're applied to the facts of real-life situations, are a little bit easier to understand, and I hope those examples helped a bit. Now, practically speaking, as a QME, I'm asking you, I encourage you to place yourself in their position. Pay close attention as you read the attorney's cover letters to see if they're indirectly corralling you to be part of one of these fund applications. How would you know? Well, let's say the applicant, Mrs. Jones, for instance, has a prior disability rating involving her left upper extremity, and now she claims to suffer a new injury, right upper extremity, industrial related, and they're asking you to opine and provide conclusions. So let's go back. As we discussed earlier, what is the one consideration in filing one of these applications? The subsequent injury must affect an opposite and corresponding member, and the disability from the subsequent injury must be equal to 5% or more of the total, without adjustment for age, occupation, or apportionment. Now, in this instance, the applicant attorney is counting on you to conclude that Ms. Jones suffered a subsequent impairment to her right upper extremity, and the disability from the subsequent injury must be equal to 5% or more of the total. So if that's your opinion, then I'd be willing to bet that you are providing an opinion and a conclusion that will be part of the subsequent injury benefits trust fund filing for this employee in the future. Well, doctors, I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I look forward to sharing other interesting subjects as they relate to topics involving workers' compensation in the state of California. Until next time, thank you.